I know many of you, for those I don't know, I'm James Strabopoulos. I'm the Associate Dean here at the Law School, and it's my great pleasure this afternoon to welcome our visitor. Before doing that, I want to take a moment to thank the person who made this visit possible, who took the initiative and arranged for Professor Moran to join us, and that's our long-serving adjunct professor, Ricardo Federico. Thank you, Ricardo, for doing this, for making the arrangements. In the wrongful conviction business, David Moran is pretty well known, and unfortunately, it is a business these days. When I was a law student 20 years ago, it wasn't. When Enzo and I were in law school, when we talked about wrongful convictions, we had like one case to talk about. There was the case of Donald Marshall. There was the Royal Commission inquiry report from 1989. And it was groundbreaking in Canada. But many insisted, at least those within the system, that it was anomalous. A collection of unique circumstances came together in poor Marshall's case, racism, police corruption, and the like, to result in that wrongful conviction. And time has shown differently, and in particular, DNA has really been the leveler in this field. It's pointed a light on the fallibility of the criminal justice system and led to the exoneration of the innocent. Now, David Moran is a professor at the University of Michigan Law School, and he is someone who has been very active in the field of wrongful conviction. He has founded a clinic at Michigan that focuses on helping the wrongfully convicted, or the people who claim, an innocence project, that they were wrongfully convicted, and a project that specifically aims to help those who aren't involved in cases that have DNA at their disposal. Those are the tough innocence cases. DNA cases are the easy ones. Everyone, lots of clinics have managed to reveal wrongful convictions where there's been DNA evidence to unearth that could be tested based on exhibits that are in storage to reveal that the wrong person was convicted. The non-DNA cases are tough. Some people don't touch them with a 10-foot pole. David has made it his business to take those cases on. And we're very pleased to have him here today to talk about one of those cases in particular, the case of David Gavitt. And what the story he's going to tell us will expose, I think, is the fallibility, again, some of the looser sciences, quote unquote, and arson science is a great example. There is increased acknowledgement within the criminal justice field that arson science, as it's historically been understood, isn't science at all. There's the case that David's going to speak to us about, but there's a rather infamous case from Texas where many worry that Todd Willingham was put to death based on faulty arson investigation. So I'm sure that David will shine a very bright light in his talk on why we need to worry about arson science. David, without any further delay, welcome. Thanks.
Thanks. I don't see a clock within view, so I'm going to prop up my watch and see if my laptop still connected good. Thanks very much. It's a real pleasure for me to be here in Toronto, where I spent a number of summers as a boy, because my grandparents lived in the Rexdale neighborhood. You're nodding. That's near here, right?
Not far.
Yeah. On Belcar Street. And I don't know where that is, but they're dead. But I spent a number of wonderful summers in Toronto and have very fond memories, but haven't been up here very much at all for decades. And so it's a real pleasure to be back, even briefly. Since I have quite a bit of time allotted, I'm going to sort of do a meandering trip to the exoneration of David Gavitt, which is, of course, the payoff, the promise of this talk. Let me get rid of the backup here, and I'll just show you the photo. This is the exoneration of David Gavitt. This is June 6, 2012, about 7 months ago. This is Mr. Gavitt walking out of the Carson City Regional Correctional Facility in Carson City, Michigan. This is my staff attorney, Imran Syed. This is my former co-director. There's me hiding in the back. And Mike McKinsey, a lawyer from Atlanta who helped us on this case. And hidden behind Mr. Gavitt is another one of our students, Caitlin Plummer, who worked on this case for 3 years. So how did Mr. Gavitt get exonerated on June 6, 2012 of 3 counts of first-degree murder for murdering his wife and two young daughters. And so how we get there, I'm going to start first of all on the theme that you heard a little bit in the introduction about the rising acknowledgement that the criminal justice system can misfire. And this is a phenomenon we're particularly familiar with in the United States, but you're also familiar with it here in Canada. You've had an inquiry in the Guy Paul Moran case, and you've had a number of other high-profile wrongful convictions. And indeed, this is something that we're now becoming familiar with around the world. The Michigan Innocence Clinic, of which I'm now the director, is one of roughly 65 innocence projects and clinics around the world. Most of them, a majority of them, are still in the United States. But there are several here in Canada, and there are also now projects in Japan, the Czech Republic, Italy, several in the UK, and there is a nascent project forming in China, I'm happy to report, a country that may have one of the worst wrongful conviction problems in the world. So most of my focus will be on the United States because I'm most familiar with the judicial system and the wrongful conviction problem in the United States. But from time to time, when I have some knowledge about international wrongful convictions, I'll try and toss that in. So the prevailing paradigm in the United States for generations was that the criminal justice system was almost infallible. Because we have a strong Constitution, and the Constitution provides all of these protections for defendants, including the right to counsel, the right to confront one's accusers, notice, opportunity to get discovery before trial. The thinking is that having a wrongful conviction is about as likely as being injured by a meteor. To throw in a reference from today. It's something that just doesn't happen. It almost never happens. One of our most famous judges never to become a U.S. Supreme Court justice, Learned Hand, said it is an unreal dream. The idea of a wrongful conviction is an unreal dream. It makes for great movies and books, but it doesn't really happen. And that was the dominant paradigm in the United States. One of the men who is on the Michigan Supreme Court wrote an article in the 1980s when he was in the Justice Department, arguing that people who were in support of the death penalty in the United States had nothing to fear for wrongful convictions. The possibility that anybody who'd been sentenced to death in the United States was actually innocent was negligible. And he wrote that article in 1987. And the first exoneration off death row in the United States occurred just 5 years later, and it's been followed by 22 more, which has led to a widespread loss of support for capital punishment in the United States. So what happened? Of course, the answer we know is DNA. In roughly 1990, DNA began being used retrospectively. It had been used a few years before that, prospectively in criminal cases when people had been charged and arrested. But people very quickly got the idea of we can go back and we can test old convictions and see if the convictions were in fact valid. I should pause here and define a few terms I'm going to use throughout this talk. One of the terms I'm going to use, I've already used, in fact, is exoneration. And before I give my formal definition of that term, I should give the definition of another term, which is actual innocence or actually innocent. And so by actual innocence or actually innocent, I mean somebody who had nothing to do whatsoever with the crime for which they were charged and convicted. Of course, there's other ways in which people can be innocent. People can have valid legal defenses, such as insanity or intoxication or duress. There are ways in which people are innocent of the crimes for which they were convicted, but really bear some criminal responsibility for the incident nonetheless. For example, you were convicted of a murder when really it was in the heat of passion and should have been only a manslaughter. So by actual innocence, I'm meaning people who had nothing to do with the crime and were the wrong person if indeed the crime occurred at all. And then by exoneration, what I mean, and that's fine that goes black. By exoneration, what I mean is that a person's conviction is overturned because of new evidence of actual innocence. That's why I needed to define actual innocence first. So having your conviction overturned does not necessarily indicate actual innocence. Convictions are overturned in the United States, and I'm sure Canada, for all sorts of reasons, such as errors in instruction, errors of counsel, prosecutorial misconduct during trial. But what we're focusing on is cases in which people have had their convictions overturned because of new evidence showing that they, in fact, were actually innocent. Okay. Now, having defined those terms as carefully as I can, we turn to what happened beginning in 1990, which is the wave of DNA exonerations. And we are now just over 300 DNA exonerations in the United States since 1990, about 20 of them off of death row. And all across the country, every state, I believe, has now had at least one DNA exoneration. And what have the DNA exonerations taught us? Well, two fundamental lessons come from the DNA exonerations. One is that wrongful convictions are a lot more frequent than we thought. That it's not like getting hit by a meteor. It's something that happens much more frequently than we thought. And when wrongful convictions happen, they're very costly. So that's lesson one. It's a bigger problem than we thought. And lesson two, which is going to eventually segue into David Gavitt's case, is what causes wrongful convictions. We can learn from the DNA cases what goes wrong by using them as experiments. By going back and looking at the case in which somebody was sent to prison or death row for a crime they did not commit, and asking, let's read that trial transcript, let's figure out what went wrong. And by doing that, we can learn a lot of valuable lessons that can help us going forward, but can also help us in cases not involving DNA, which is where I come in. So going back to the first lesson about what have we learned from the DNA exonerations, number one, there's a lot more a lot more wrongful convictions than we thought. Over 300 now. And based on just those 300 DNA exonerations, we're able to get some idea of the scope of the problem. So how do you get some idea, how do you extrapolate from 300 DNA exonerations to how big a problem is wrongful convictions in the United States, or for that matter, around the world? Well, you can use databases. And two studies have been done, one by my colleague at Michigan, Sam Gross, and another by D. Michael Reisinger at Seton Hall Law School, who have attempted to estimate the wrongful conviction frequency using just the DNA exonerations. So what one of the studies did was it looked at people who were convicted of capital rape murder anywhere in the United States from the early 1980s to the early 1990s. That period was chosen because that's a period before DNA testing was done. But there are a significant number of such cases. So these are cases in which somebody was sentenced to death or eligible to be sentenced to death for a murder involving a rape anywhere in the United States. And these cases are very well studied, and they tend to be pretty well litigated after conviction. And so we have a pretty good idea of what happened in all of these cases. And using the DNA exonerations just from that subset of cases, Professor Reisinger came up with an estimate of 3 to 5% of a wrongful conviction rate. Now, there's multiple ways to look at a 3 to 5% error rate. One way to look at a 3 to 5% error rate is that anything humans do with 95, 97% accuracy is pretty good. For example, shooting free throws. If you had a basketball player who could hit 95 to 97% of his or her free throws, that would be one of the best free throw shooters in the history of basketball. So that's really good. On the other hand, would you board an airline that promised you a 3 to 5%, only a 3 to 5% chance that the plane would not crash before reaching its destination? Of course, nobody would. So, of course, numbers like 3 to 5% have to be taken in context. How bad is a 3 to 5% error rate? The other study done by Sam Gross came up with a remarkably similar number, 3.3%, using rape kits collected by the Virginia State Police over roughly a 30-year period. It turns out that whenever there was a rape in Virginia in which a rape kit was collected from the victim, the Virginia State Police stored it forever. And so there was this warehouse full of rape kits, most of which had never been tested. And it was possible to take a large sample of these rape kits and test them and to see if the DNA matched the people who had been convicted of those rapes. And in just over 3% of the cases, it did not. So that led to several exonerations in Virginia. But in many of the cases, the defendants had already served their prison sentences or had died. So a remarkably similar sort of number. Now, because I have a scientific background, I don't think it was mentioned in the introduction, I have degrees in math and physics before I changed course and ended up going to law school. So because I have a scientific background, I'm always careful to caveat these sorts of numbers, these 3 to 5% numbers. We have to be very careful in extrapolating them to wrongful convictions generally. We just don't know. These are two very specialized databases, rape murders across the United States in the 1980s and roughly 30 years of rapes in Virginia. Rapes and rape murders, of course, are the crimes for which you're most likely to have a DNA exoneration because they are crimes for which the perpetrator is especially likely to leave behind biological evidence. In the vast majority of criminal cases, there is no biological evidence left behind. So can we extrapolate from this specialized subset of cases almost an overwhelming majority of which involve sexual assault, can we extrapolate from that to wrongful convictions generally? Answer, we don't know. So we have to be careful in making this extrapolation. There are some crimes, I think, in which the wrongful conviction rate is probably higher than it would be for rape or rape murder. For example, I think armed robbery or robberies generally, the wrongful conviction rate is probably higher because robberies very often involve a single eyewitness who observed the robbery under wretched conditions and great deal of stress, and there's often no other evidence connecting the alleged robber to the crime other than a subsequent eyewitness identification. Other crimes, I suspect the wrongful conviction rate is lower. For example, embezzlement, I suspect the wrongful conviction rate is lower. The money turns up missing from the business. There are only a couple of people with access to the account, and only one of them has a new boat. Usually the trail is pretty strong, and the chance of a wrongful conviction is probably not so high. Though I don't know that, that's just my intuition. So I'm very careful about extrapolating. But nonetheless, a 3 to 5% wrongful conviction rate in these types of major cases in which the punishment is very severe, which would suggest that there would be a lot of attention from the criminal justice system to these sorts of cases, to many people it was shockingly high. And it's especially so when we think about the costs of wrongful convictions. How much does a wrongful conviction cost us? And this gets back to is it more like missing free throws or is it more like a plane crash? I think it's somewhere in between, but I think it's closer to the plane crash, though not as grim, than it is to the missed free throw when we factor in what are the costs of a wrongful conviction. Well, the obvious cost is the wrong person goes to prison. And that person, we now know from these hundreds of exonerations, suffers tremendous mental and emotional costs, the loss of family relationships, the not being there when family members die, not being there for their children who often then turn out to have all sorts of problems of their own, the loss of their productive. Many of the people who've been exonerated turn out, when you look at their histories, they were not career criminals. They were people who had normal, regular jobs. So the loss of their productivity, the loss of their taxes even. So that's one cost, the huge cost to the people who are wrongfully convicted. And this is a question, by the way, I sometimes throw out when I speak on this subject. How much should we compensate somebody who has been wrongfully convicted? I was just yesterday in Lansing, Michigan, meeting with the governor's staff. We're trying to pass a compensation bill in Michigan. And how much is enough? The current bill would provide $60,000 for every year of wrongful compensation. So I often toss out when these numbers are around, how much would it cost, how much would the state have to pay you to agree in advance to a year of wrongful incarceration or 5 years of wrongful incarceration? Very few people would say they'd do it for $60,000. Something to think about. So there's that cost. And then there's the cost to society of the wrongful incarceration. First of all, there's the obvious cost of locking somebody up. In Michigan, it costs $32,000 a year to lock somebody up. So that's a cost to the state. If you do the math and you were to extrapolate from the 3 to 5% numbers based on the roughly 45,000 prisoners we have in my state of Michigan, that would be that Michigan spends roughly $45 million a year on incarcerating people who are innocent, which is a substantial, not treasury crushing, but substantial amount of money that the state spends and other states spend on locking up people who shouldn't be locked up. But another substantial cost is that when we choose the wrong person in a crime in which there actually is a perpetrator, it means the criminal justice system is not focusing on the real perpetrator. And the real perpetrator, our experience has shown in the Michigan Innocence Clinic and shown around the nation, perhaps feeling quite good about himself or herself for having gotten away with this crime, often goes on to commit more crimes. And so in the cases that we've litigated in the Michigan Innocence Clinic, the 7 exonerations that we've had so far, in 4 of the cases, the evidence we found exonerating our client implicated the real perpetrators. And those people we discovered, we believe, went on to commit between them at least 7 murders and many other crimes, carjackings, robberies, and other crimes. To take just one example from Michigan of this case, not one of our cases, there was a woman who was raped and murdered in her community college classroom at Lansing Community College in Lansing, Michigan. She was a professor. She was teaching a class. She was scheduled to teach a class, and when the students arrived, they found her dead. And the police immediately focused on the mentally ill homeless guy who hung out on campus. And they arrested him, they interrogated him for hours, and eventually, after hours of interrogation, they got him to say that perhaps he had, well, his whole interrogation didn't make sense because the man was severely mentally ill. But after a couple of hours, he agreed that perhaps in one of his mental states, he may have raped and murdered the professor. The DNA was inconclusive in the case, so he was convicted entirely on the confession. And 2.5 years later, he was exonerated when it turned out that all the time the prosecution had a security video from the campus library showing that Mr. McCollum, Claude McCollum was his name, was asleep in a chair during the entire period during which the murder could have occurred. And shortly after that, the police arrested a man named Matthew Macon for the murder, and more sophisticated DNA testing matched Mr. Macon to the murder of Carolyn Cronenberg. But during the interim, Mr. Macon had murdered 3 other women in the Lansing area. And so you wonder, you can't know, but you wonder if the criminal justice system were better at the outset and hadn't focused on the wrong man, might they have found Matthew Macon earlier? And in case after case, we see these questions. If the criminal justice system were better at identifying the real perpetrators early on, could they have prevented the real perpetrators from committing further crimes? Obviously not in every case, but in many cases, you would hope so. Okay, so the cost of wrongful convictions are high, and there's a lot more of them than there used to be. That's lesson 1 from the DNA exonerations. Lesson 2 is what causes wrongful convictions. And here, great work has been done. First of all, the Innocence Project, which is the first Innocence Project in the United States, the Innocence Project, at Cardozo Law School in New York, founded by Barry Scheck and Peter Neufeld, has made a project of examining every DNA exoneration in the United States. If you're not familiar with their website, innocenceproject.org, they have information on every DNA exoneration in the United States. You can click on links and read all about these cases. And what they have done is gone back and looked at every one of these cases and asked what went wrong? What caused the wrong person to be convicted? A similar project was undertaken, it's 2013, I guess a year and a half ago, 2011, by Professor Brandon Garrett at the University of Virginia Law School in his book, Convicting the Innocent, which I also highly recommend. And in Professor Garrett's book, he had his hapless law students' assistants read every transcript of every DNA exoneration, which must have been tedious. You got to give credit to those students. They went and cataloged the things that went wrong in these trials that led to these innocent people being convicted. And the results of the Innocence Project studies and Professor Garrett's studies are remarkably consistent. The same 6 things come up over and over and over again. First is bad eyewitness identification procedures. 75% of the DNA exonerations involve somebody pointing at the defendant and saying, that's the guy, I'll never forget the face, that's him, no question. And it turns out through a DNA test years later that they were wrong, sometimes egregiously wrong. I'm very good friends with one of the DNA exonerees in Michigan, a man named Ken Winnimko. He was the manager of a bowling alley when he was convicted of a rape based on a bad eyewitness identification. They had published a picture of the rape, or a sketch of the rapist in the local newspaper, and somebody called the police and said, that looks like the bowling alley manager. And then the victim identified Mr. Winnimko. Mr. Winnimko, at the time of the rape, was 43 years old. He was 180 pounds, 5'10". So my height, I'm 5'10", 180 pounds. Years later, after he was exonerated, the DNA matched a man named Craig Gonser, who it turned out was a serial rapist and who committed more sexual assaults while Ken Winnimko sat in prison. And it turned out Craig Gonser was, at the time of the rape, 28 years old, so he was 15 years younger than Ken Winnimko, 6'6", 8 inches taller, 380 pounds. An enormous, tall, fat guy. Plump doesn't get there. Fat guy who bore no resemblance to Ken Winnimko. So in many of the cases, the eyewitness identification procedures have produced egregiously wrong results, and we know that there are better ways to do it. There are better ways to perform eyewitness identification that will not eliminate wrongful or misidentifications, but will make the identification process better. And I'm very happy to say that the Michigan police, last month, after a task force in which I was a member, came forward with recommendations for improving eyewitness identification procedures, requiring sequential blind identification procedures and recording of the whole thing. The Michigan police have adopted those procedures. Michigan is now about roughly the 10th state in which eyewitness identification procedures have been improved as a result of the exonerations. A second leading cause of wrongful convictions that shows up again and again is false confessions. In 25% of the DNA exonerations, about 80 of the DNA exonerations so far, the defendant said, I did it, as in the case I already mentioned, Claude McCullum in Michigan. In some cases, multiple defendants have said that they did it. In fact, the research tends to suggest it's easier to get multiple false confessions than it is to get one, because once you get one, or even you claim you have one, it's easy to get other defendants then to cave in as well. You say, the other guy said, I did it, and he blamed you, and the pressure becomes unbearable, and the defendant confesses. Again, for those of you who want to do further reading or further watching, I have some recommendations on this. There is a wonderful documentary done by the American PBS Frontline about the Norfolk 4 case, in which 4 American sailors were coerced into falsely confessing to a rape and a murder there. And so if you just Google Frontline Norfolk 4, there is one of the best documentaries I've ever seen, Norfolk Frontline, about that. There's a film that came out this year by the filmmaker Ken Burns about the Central Park 5, in which 5 young men were coerced into confessing to raping a jogger in Central Park in the late 1980s and were eventually exonerated by DNA. Again, there are ways we know that can make this sort of thing less likely to happen. Foremost among them is videotaping. If the interrogation, the entire interrogation, is video recorded, so that the lawyers, the judge, the jury can see if coercive pressures were used, or if the person was intoxicated, or the person was not in his or her right mind, we're much less likely to get a wrongful conviction. And we're also much less likely to have egregious coercive police tactics if the police know that the whole thing is being recorded for posterity. A third leading cause of wrongful convictions is police and prosecutorial misconduct. And what we're talking about here is typically withholding evidence. I'm not an expert on Canadian discovery, and Federico just walked out the door. Maybe you can tell me.
It's much more liberal than Brady now.
That's good.
Yeah.
That's good.
There was a time when it was a lot worse than Brady, for a long time, actually.
Worse than Brady?
Yeah.
Man, that's bad.
Yeah.
Yeah. Unfortunately, there is a lot of game playing by prosecutors and police officers withholding cards, some of which is innocent, because sometimes prosecutors and police officers form a tunnel vision where they think they've got the right person and they're incapable of seeing the broader picture and seeing possible flaws in their theory. And so as a result of that, they don't see other pieces of evidence as relevant as something that the defense needs to know about, because that's completely irrelevant. It has nothing to do with it because, of course, the defendant did it. And it is a consistent theme in the wrongful conviction cases that there was a piece of evidence sitting there that if the defense had, it probably would have come out differently. And it's certainly one of the most common things we see in the cases that we litigate. A fourth leading cause, and one of the leading causes in my state, Michigan, is ineffective assistance of defense counsel. Throughout the United States, we have a patchwork system of how you get lawyers for poor people who are accused of serious crimes. Michigan, a national study concluded, had one of the 5 worst systems in the country. In Michigan, a lawyer can be paid $100 to defend a felony case and may take hundreds of cases, have hundreds of cases at once, and has no time and no resources to devote to any of them. And so the only thing that the lawyer can do is work very hard on his or her clients to force them to plead guilty. Because if the case goes to trial, the lawyer will take a bath financially trying to defend the case. This is another thing we're trying to reform in Michigan. In fact, the meeting I had yesterday with the governor's staff was in part about our system of indigent defense in Michigan. Just to throw out one number directly relevant to forensic science. In Oakland County, Michigan, which has 1.2 million people, the total budget for the 7,000 felony cases last year, 7,000 felony cases, the total budget for indigent defendants to have investigators and experts was $25,000. So that's basically one case. And once that money's gone, no one else can get any private investigators to help track down witnesses. No one else can get expert witnesses to help their defense lawyers. And that is a problem throughout the United States. A fifth leading cause is the use of jailhouse informants. Something I understand that Canadian courts are familiar with, and Canadian courts have become more skeptical about. Unfortunately, there's been very little reform efforts here. In 20% of the cases, DNA exonerations in the United States, there was somebody who was in jail for another crime who says, I heard the defendant admit that he or she committed this crime. And of course, there are all sorts of incentives for why such people will make such statements, which turn out to be, in case after case, patently false. And finally, number 6. Like I said, I'm winding my way to the exoneration of David Gavitt. Number 6 is bad forensic science. In 52% of the DNA exonerations, somebody wearing a white coat, or somebody who, figuratively anyway, would be wearing a white coat, came into court and said, I did some experiment, or I did some analysis, and this evidence matches. And that testimony turned out to be wrong. 52% of the DNA exonerations. Give a few examples of what I'm talking about here. The problem can really be subdivided into 2. One is bad science, junk science, where somebody comes in and gives testimony that is just not scientifically valid at all. And Exhibit A in the United States has been so-called bite mark testimony. There have been nearly 24 exonerations after people were convicted based on forensic odontologists who are dentists, who come in and say, I found a mark on the body, and I was able to match that to the defendant's teeth. It turns out there's no scientific basis for that sort of matching at all. It's purely interpretive and it's guesswork. And in many of these cases, after the exonerations, when we've gone back and looked at the marks on the body, they weren't bite marks at all. They were insect bites. They were abrasions where the body had been dragged. There is no scientific validity to bite mark testimony. Hair analysis is another one that is especially bad. So there'd be hairs found at the crime scene. The expert would pull some hairs from the defendant and say, they match. Well, what does that mean? What does to say they match mean? It means they look alike to the expert. Well, it turns out that there is nothing unique about hair. Lots of people's hair looks alike. And in addition, even the hair from the same person's head doesn't look alike in the same place. If you pull a hair from a temple and you pull a hair from the back of the scalp, it will look different. And so these are entirely subjective, standard-free analyses that were used to convict many people and send some of them in the United States to death row. So there's bad science, and then there's bad scientists, or bad forensic scientists. In the United States, we have had crime lab scandal after crime lab scandal. The FBI crime lab had a scandal. The Oklahoma City crime lab was shut down. The Detroit crime lab in my state was shut down. The Houston crime lab, one after another after another. Just most recently, we learned that in the Massachusetts State Police crime lab, the woman who, apparently there was only one woman in Massachusetts whose job it was to take seized drugs, or seized alleged drugs, and confirm they were drugs. And she was making it up. She was just testifying or sending reports year after year saying, yep, that's cocaine. Yep, that's heroin. When in fact she wasn't even performing the tests. There have been pathologists, forensic pathologists, a similar sort of thing in Texas, a man named Dr. Ralph Erdman in the west part of Texas, who testified for the prosecution in case after case, and always his testimony exactly matched the prosecution's theory as to how the murder occurred, where the bullet came in, shot in the back, if that was helpful for the prosecution. And it turns out he wasn't performing autopsies at all. He was making it up. He was literally making it. He was finally caught, Dr. Erdman was, when he testified about his examination of a victim, and he mentioned the victim's spleen. The victim didn't have a spleen. Her spleen had been surgically removed, and her family raised some questions, and eventually that led to a wide-ranging investigation that led to Dr. Erdman being removed. Fred Zane, who was the head of the West Virginia State Police Crime Lab for years, same thing, came in and gave testimony after testimony that just exactly fit what the prosecution needed, and he was making it up. So this is the focus of my talk, is about forensics. But the forensics problem is especially widespread and especially bad. And after so many of these high-profile cases, crime labs being shut down, fraudulent testimony being given in case after case, the United States Congress jumped into action, which is rare, and charged the National Academy of Sciences, which is the most prestigious scientific body in the United States, to examine what is the state of our forensic system. And in 2009, the National Academy of Sciences issued a report, which again is one of these things you can find online. I don't expect you to read it. It's 400 pages, single-spaced, but it has a good executive summary. I do assign the executive summary to my students. And what the National Academy of Sciences concluded was that forensic sciences in the United States was fundamentally unreliable. With the exception of DNA testing, all of the forensic testimony given in American courts was not scientifically validated. Even fingerprints, people assume fingerprints is scientifically validated. When a fingerprint expert gets on the stand and says there's a match, there's a scientific basis for that statement. It turns out that's not true. We had a high-profile case in the United States. Have you folks heard of Brandon Mayfield? Do you know who he is? Some nodding. There was the Madrid train bombing carried out apparently by an Al-Qaeda affiliate in Spain in 2004 or 2005, I forget. And fingerprints were found on a bag of explosives on one of the trains. The fingerprints were published by Interpol, and the FBI crime lab matched the fingerprints to Brandon Mayfield, who was a lawyer living in Portland, Oregon. His fingerprints were on file because American lawyers, when we take the bar, we have to get fingerprinted. Do you have to get fingerprinted in Canada when you take the bar? No. Yeah. We're weird in so many ways in America. We have to get fingerprinted when we take the bar. And so his fingerprints were on file. So he was arrested and held incommunicado and subjected to aggressive interrogation until finally the Spanish police said, you know, these fingerprints actually match this Algerian known member of Al-Qaeda. and the FBI said, no, they match Mayfield. And it took another week after that before the FBI finally relented and Mr. Mayfield was released. It turns out, though, that there is no scientific basis for declaring that two fingerprints match. It is a subjective determination where you look at the latent print and you look at the suspect's comparison print. And different examiners have different standards as to when they declare a match or when they declare an exclusion. There is no scientific basis, even though fingerprint examiners come into American courts every day and say, to 100% certainty, that fingerprint belongs to that guy. Turns out there is no basis for that testimony, and it's certainly false that to 100% certainty they can say that there is a match. The National Academy of Sciences report had 13 recommendations. I'm certainly not going to go through all of them. But the major ones was that Congress set up a National Institute for Forensic Studies, forensic standards, which would conduct scientific studies so that we can say what is the probability that this fingerprint comes from this particular defendant, given that it matches at this many points. What is the probability that this tire track comes from this particular car, given these matches between the pattern left in the mud and this photo of the tire track, and so forth. But until these studies are done, the National Academy of Sciences said forensic testimony declaring matches like this simply should not be given in the United States. The NAS study also recommended that crime labs be separated from the police. Virtually all crime labs in the United States are controlled by the police. In Michigan, then the crime lab is the Michigan State Police Crime Lab. And so that gives the forensic scientists who work there a strong incentive to come up with results that match what the police want to hear, which is, we've arrested the right suspect. And so the National Academy of Sciences urged that crime labs be made independent from police so that they do not have those sorts of incentives. They also urged that all people who work in crime labs be accredited and certified, and the crime labs themselves be accredited, something that shockingly is not done. Virtually, there is no national body that accredits crime labs or certifies forensic scientists. And so the credentials that will get you into a court to testify against somebody claiming that the evidence matches vary from jurisdiction to jurisdiction, frankly vary from judge to judge. What will the judge allow in as sufficient credentials? An issue that we'll see as we turn to the Gavitt case. Okay, so those are the lessons that we've learned from the DNA exonerations. Wrongful convictions is a much bigger problem than we thought. It costs us a lot, and here are the causes. But the DNA exonerations are a very small part of the pie. Estimates vary, but we think that between 1% to 3% of all felony convictions in the United States involve DNA left behind by the perpetrator. In the vast majority of cases, there is no DNA left behind by the perpetrator. In a robbery case, a burglary case, most murders, especially murders by gunshot, there is no DNA left behind by the perpetrator. But there is absolutely no reason to think that these same problems that have resulted in the DNA wrongful convictions and later exonerations, there's no reason to think that these same problems are not equally prevalent in cases in which there is no DNA. The DNA cases are a small piece of the pie. They're primarily, as I've already indicated, rape cases. But there's no reason to think that these same problems, police misconduct, bad lawyers, jailhouse snitches, bad eyewitnesses, and forensics do not crop up in cases in which there is no DNA. So that is why in 2009, I co-founded the Michigan Innocence Clinic, which was the nation's first innocence clinic or innocence project exclusively dedicated to cases in which there is no DNA. Now, Why did I do that? It's not because I especially like hard work, as the introduction indicated. It's because in Michigan we already had a DNA innocence project at Cooley Law School in Lansing, Michigan. And so we decided we are not in the business of competing with another innocence project that already existed in our state, but that realizing that they were only going to get a very small piece of the problem, Bridget McCormick and I decided to form another clinic. By this point, I had already been involved in 7 exonerations. From 1992 to 2000, I was at the State Appellate Defender Office in Detroit, Michigan. And that office takes appeals on behalf of indigents who have been convicted anywhere in the state of Michigan of any kind of crime. And I worked there for 8 years, and I was assigned 200 cases, and 7 of them turned out to be exonerations. 7 of them, we found new evidence of actual innocence that caused the convictions to be overturned, and in all 7 of these cases, the defendants were not retried. The prosecution gave up in light of the new evidence that we found. And so I knew that there was a serious wrongful conviction problem in Michigan already that did not involve DNA. Bridget, who by that point had been at the clinical program at the University of Michigan Law School for about a decade, and had litigated various types of cases, was also aware, because she had had 2 or 3 non-DNA exonerations by that point herself. And so we got together. I was associate dean at Wayne State Law School at the time. I'd just gotten tenure a couple of years earlier. I was, going to just be a research professor. But I got together with Bridget, and we started talking about this idea of starting a non-DNA innocence clinic. And I said, great. So I gave up my tenure, became a clinical professor at Michigan, and we formed the first non-DNA innocence project. We got a lot of mail. We got 4,000 applications within a few months of before we opened. When the media publicized that we were about to open this project, within a month, we got over 1,000 letters. We devised a questionnaire, and we came up with a system that we followed to this day. I'm now the director because Bridget McCormick, my co-director, in November, 3 months ago, was elected to the Michigan Supreme Court, which is good. Very bad for me, but very good for the state. So now I'm the director, and hopefully I'll have a co-director again in a year or so after we do a search. So the system that Bridget and I came up with was somebody writes us, it had to be from Michigan because we're geographically limited. They say, help, I'm innocent. We send them a 19-page questionnaire. You can get it off our website if any of you are curious. Michigan, www.law, that was too many W's, wasn't it? www.law.umich.edu/innocence clinic, one word. That's our website. You can read about some of our cases there as well. There's an application you can download from that page. 19 pages of questions, and the questions ask about your case. What happened in your case? And we ask, was there an eyewitness identification? We want to know how the eyewitness identification, if there was one, was conducted. Did you confess? Why did you confess if you didn't do it? What kind of scientific evidence was used to convict you? Who was your lawyer? It's a question that's very important to us because we know certain lawyers in Michigan, and even though on camera I'll use the word suck. And so with certain names, we know the person automatically did not get an adequate defense. Who was the prosecutor? We know certain prosecutors in Michigan are dirty, withhold evidence in case after case, or will do anything to win a case. So we see that name, that's a red flag for us. Who was the judge? Certain judges in Michigan are terrible, and we know that. So we learn as much as we can about the case, and we had 2 students for each application review it independently. The students have to agree not to talk about the case, and they each write a little memo. And the memo is designed to answer 2 questions. 1, is there a chance in hell that this person might actually be innocent of the crime? And 2, if so, is there a chance in hell that we might be able to find new evidence to prove it? We can't go back to court and say, you should release this guy because the jury must have been out of their mind. we have to go back to court with new evidence that wasn't presented before to convince the judge that this person was innocent. What we do, if we do take a case, is we file what's called in Michigan a motion for relief from judgment. In many other American states, it's called state habeas. We go back to the same judge in front of whom the defendant was convicted, and we say, here's new evidence that will make a different result on a retrial very likely. You should grant a new trial. So we have to initially decide, is this a case in which it's possible this person could be innocent, plausible, this person could be innocent, and plausible we could find something that could prove it. 85% of the time, we reject the case at this stage. We get lots of mail, lots of applications from people who are plainly not innocent. They don't like the sentence they got. They don't like prison, but they're not innocent. So 85% of the applications we reject at that stage. If the case passes that, then it gets assigned to a team of 2 students, and it becomes what we call a further investigation case. Since we opened our clinic, we have designated for further investigation somewhere between 200 and 300 cases. And what our students do is they go and they try and track down what happened in the case. So they'll get the transcripts in most cases. They'll talk to the prior lawyers. But in many cases, it's about trying to find the new evidence. So the person claims in the questionnaire that there was Bertha Jones saw what really happened. So the students were going to, as part of the further investigation, are going to try and find Bertha Jones. Our students effectively become private investigators. They travel the state, they knock on doors, they try and find new witnesses, they try and find smoking gun documents, they try and find anything that can establish or disprove, because we want to keep an open mind in all these cases. We're as much looking for evidence that shows that the right person is in prison as the wrong person. Again, somewhere between 85 and 90% of our further investigation cases we end up rejecting. Students do an investigation, they say, you know, the evidence against this person is really pretty strong after all, and he probably did it. Or he may be innocent, but there's no way we can prove it. Or he may be innocent, but all the evidence of his innocence has already been presented and rejected. There's nothing left that we can possibly present. So we end up rejecting the vast majority of our further investigation cases. Since we opened January 2009, we have, as I indicated, screened close to 4,000 cases. And we accepted case number 22 yesterday. And we have so far won 7 exonerations of people who served between them 84 years in prison and would have served well over 100 years more had they not been exonerated. We have 14 cases still open. So far, that's not wood. So far, we have not lost any. We've lost rounds in cases, and some of the cases that we have open. So we currently have 14 open cases now. Some of them we probably will lose ultimately, but we haven't yet. So that's long introduction about the problem of wrongful convictions, our clinic, and how we get cases. Now, I think I'm going to have to restart my computer. Here we go. I'll talk a little bit about David Gavitt. He's exoneree number 6 for us. This is bridge. Nope, it's not on the screen. Probably sat too long. No problem. David Gavitt was among the first people to write us. And, nope. And so he was among the very first batch of cases that we designated for further investigation. So let me tell you a little bit about his case. David Gavitt lived in Ionia, Michigan, which is halfway between Lansing and Grand Rapids on the west side of the state. He was, in 1985, he was 27 years old, and he lived in this small town, about 8,000 people. Nope. See, this is why I'm a very low-tech guy. It's very rare for me to actually ever use technology in a talk, and I'm feeling better about that as we go. So David Gavitt lived with his wife, Angela. That was his high school sweetheart. They met in high school. They got married just after they graduated high school. And he worked in a factory in Grand Rapids. She worked in the same factory. And they had, there we go.
Yeah, it's back. Cool.
Yeah, it's back. Both screens, awesome. He worked, and they had two small children, ages 2.5 and 8 months. That's kind of small, so if I make it a little bigger. Whoops. That's Angela and David Gavitt and their dog, circa 1984. March 9th, 1985 was the day that changed everything. That was a Saturday. There was a snowstorm that day. And that night, Angela and David, this is a story, I should preface this. This is a story that David has always told about what happened that night. He and Angela they got the kids to bed around 10 p.m. They were watching TV. They were smoking. They were both smokers. They had candles lit. They were hanging out with the dog in the living room when they decided, my God, we've got the kids to bed. Let's go have sex. So they went to the bedroom, and they closed the door, and a few minutes later, David heard the dog scratching at the door. He opened the bedroom door and looked down the hall, and there was an inferno coming from the living room where they had been a few minutes earlier. He immediately ran across the hall to the guest bedroom, smashed out a window to make an escape route, because the front door, to get to the front door of the house, you had to go through the living room. So he smashed a window in the guest bedroom, which made things worse, undoubtedly, because it created a draft through the house. Meanwhile, Angela went down the hall one room towards the living room to the nursery where the two girls were to rescue them. David then, having smashed the window and lacerated himself terribly in doing so, then went down the hall towards the nursery, but couldn't make it there. He was overcome by the heat and the flames. And he then turned around and went out the guest bedroom, the window he'd broken in the guest bedroom, fell into a snowbank outside. By this point, the neighbors were aware that the house was on fire. The neighbors came over, and they watched David as he ran around the house, bleeding profusely. By this point, he's very badly burned. He's wearing only jeans, because, of course, he was naked at the moment that the dog scratched at the door. He did manage to throw on jeans, no underwear, no socks, no shoes, no shirt in the freezing cold. They watch him run around the house to the nursery and trying to fight his way through the window of the nursery, which is, by this point, fully engulfed in flames. The neighbors then pulled him off. He was taken to the hospital, where he had second-degree burns over 80% of his body and serious smoke inhalation, and he spent the next month. Angela, I can do backup. Angela and the two girls were found dead of smoke inhalation and burns in the nursery. So David is in the hospital, and 30 days or so pass while he's there. And when it's time for him to be discharged, instead of going home, he's arrested and charged with 3 counts of first-degree murder for setting the fire that burned down the house. Now, the prosecution had a difficult case to begin with because there was zero motive. No insurance. This wasn't his house. It was his mother's house. He had no insurance money on it. There was no life insurance on anyone, as often is the case in murder cases. And there was no marital difficulty. In fact, at trial, a parade of witnesses testified that Angela and David seemed to be a very happily married young couple who loved their 2 children very much. So how was David Gavitt convicted of first-degree murder and sentenced to life without parole? The answer was entirely forensics. So at the trial, the state called 2 witnesses to testify that based on their examination of the fire scene, it was an intentionally set fire. I'll show you just a couple of photos from the scene. This is what the front of the house looked like after the fire. This is the living room on the right here, where the fire started. The bedrooms that I described are then down at the rear of the house from this view. This is looking down the hallway from the Gavitt's master bedroom. I should increase the size of that one. So this is looking towards the living room from the Gavitt's bedroom. This here is the door to the nursery. So the guest bedroom I described is over here. The Gavitt's master bedroom was here. You can see the couch in the living room. The TV was over there. There was a coffee table where there were candles and ashtrays and so forth. These experts came in, 2 state experts, and testified that based on their examination of the fire, it had to have been arson. And the testimony they gave was very prevalent at the time in the 1980s in fire scenes. What they said is that you can tell from certain indicators at the fire scene that a fire has been intentionally set. And here's the indicators that were important. 1, that the fire was unusually fast-moving and unusually hot. Firemen came in and said it was a really hot fire when we were fighting it. Really, I'm not making this up. And the neighbors said, it was amazing how fast this fire spread. And so this was seen as a clear indication of arson. 2, patterns on the floor in the living room. So under the carpet, there's a wood floor, and there were these black marks on the floor in various places. And this was seen then as pour patterns. They were called pour, P-O-U-R, patterns. The theory being, this is the places where a liquid was poured and then set on fire. And so if you see these look like black circles on the floor, that's an indication that an accelerant was poured on the floor. Next, something called crazed glass. So in a hot fire, the glass cracks. And the theory was that if you see a spider web type pattern, looks like a drunken spider web pattern in the glass, it's called crazed glass, that's a sure indication that an accelerant was used. Next was something called alligatoring. So wood beams, when the wood beams burns, if the pattern looks like the scales on the back of an alligator, another surefire sign that an accelerant was used, this fire was unusually hot, it had to be arson. So these guys came in and they gave, one from the state police and the local fire marshal gave his testimony about all of these signs, and so they were certain that it was arson. The most devastating testimony against David Gavitt, though, came from a professor of food science at Kent County Community College. Now, you should be asking, why would a professor of food science at a community college be testifying in this case? Good question. He testified, though, as an expert in gas chromatography. So gas chromatographs, I was trying to describe this to Ricardo before. I'll give a quick description. Actually, let me ask, how many of you know what how a gas chromatograph works? Okay, I should give the description. Yeah, I used to be a scientist, so I actually came in knowing how this stuff works. A gas chromatograph is basically a small oven. And what you do is you put a sample of whatever it is you want to test in this oven, and then you gradually heat it up. And you get a chart that on the x-axis, it has temperature. So the temperature gradually increases. And when you hit certain temperatures, so you get really hot, certain substances vaporize off. And so the gas chromatograph measures with spikes on the y-axis It measures with spikes the points at which vapor comes off the sample as it gradually gets hotter. So in food science, you use gas chromatograph. So when you hit a certain temperature, the sugar vaporizes, and so you get a spike if you got a sugary treat that's in the gas chromatograph. So this guy had never used a gas chromatograph for forensics purposes before. But he comes in and testifies that he got 17 of the carpet samples from the living room, ran them through, and on 2 of them, he saw the spikes characteristic of gasoline. And so he said gasoline was poured on this carpet. And he came up with this incredible estimate. 2 gallons of gasoline was poured on the carpet based on this gas chromatograph. Let me pause to say that there is absolutely no there is a scientific basis for saying there's gasoline on a chart, looking at the spikes. There's absolutely no basis to saying there's 2 gallons. There were no containers of gasoline found in the home. So where did this gasoline come from? Why did David Gavitt himself almost die in the fire? No explanation for any of that. But nonetheless, you have these 3 experts, 2 fire marshals and a food science professor come in and say it was arson. What does the defense do at trial? Nothing. The defense rests without presenting any evidence. In fact, the defense did not even contest that it was arson. The defense lawyer, who later became a prominent judge, I'll name him, Dennis Kalenda is his name. I'm not a fan. Felt that it was pointless to challenge any of this. And so instead the defense was, okay, it's arson, but that doesn't mean David did it. Maybe they had some enemy who firebombed the house. Maybe Angela did it. Didn't work. Just to argue those things. And so David was convicted, and 3 counts of first-degree murder, sentenced to life without parole. Fast forward 24 years to 2009. Our students read his questionnaire. They designate it for further investigation. And the first thing that they do is they send a FOIA, Freedom of Information Act request to the Michigan State Police. Say, can we get all of the photos that were used to do this evaluation? And it turns out they all still exist. We got, I think, close to 1,000 photographs like this of the Gavitt home so that an evaluation could be done of the fire. And the other thing that they got, which was frankly a miracle, this is the answer to the FOIA request. They got the original gas chromatograms. They still existed. So here's one of them. See the little spikes? That's what a gas chromatogram looks like. So why did we flag this case? The answer was because something happened between 1985 and 2009. In 1992, something called the National Fire Protective Association, which is a trade group of people who investigate fires, got some grant money, and they decided to actually test these assumptions that were prevalent in the Gavitt case about calling fires arson. And so they got this grant money, and they bought up a bunch of abandoned houses and some abandoned hotels, and they torched them systematically. Some they started electrical fires, electrical shorts. They dropped cigarettes. Some they actually poured gasoline like an arsonist would in the fire. And they set them on fire. And then after they burned, they went back to look to see if the same signs occurred. If you could tell by looking at the aftermath the difference between an arson fire and an accidental or electrical fire. And the answer, in short, is no. All of these signs that I talked about were just as likely to occur from an accidental starting fire as an intentionally set fire. Crazed glass, alligatoring, pour patterns, and especially this testimony about how really hot, really fast fire had to have been intentional. All turns out to be, I should cancel this back up so we'll stop saying that. All turned out to be completely wrong. I'm going to show you. Oh, we got sound. Before we couldn't get sound. This is a film, 3-minute film from one of their studies they did in the 1990s, where they dropped a cigarette in a chair, and watch what happens.
Air is stuffed with plastic foam. It has a fuel potential of 50,000 candles and no mechanism to control the release. The steady heat of a cigarette accidentally dropped between the cushions can create a disaster.
Is this real time?
Yep.
Initially, the burning cigarette creates a smoldering fire, which breaks down the foam stuffing into vaporous fuel. When there's enough heat and oxygen, it starts to flame. More heat produces more fuel, and the fire accelerates rapidly. Smoke and other products of the fire, including unburned fuel, collect beneath the ceiling. Within 3 minutes, the temperature at the ceiling reaches 1,000 degrees, heating the contents of the entire room near the point of ignition. The carpet and other furnishings start to break down into vaporous fuels. Then, within seconds, in a process called flashover, everything in the room erupts into flame. No life survives flashover. After all the oxygen in the room is consumed, a pulsing backdraft sucks in air from the outside, completes it in a surge of burning that breathes in more. All this took place in less than 4 minutes and started with a smoldering cigarette.
That's why you shouldn't smoke. That phenomenon, I don't know if you could hear it, flashover it's called, was unknown in the 1980s. It was discovered as a result of these NFPA-sponsored studies. The idea that the room fills with a hot gas as the furniture or the carpet burns, and then that hot gas turns basically into an explosive bomb that goes off in just a few minutes, producing incredibly high temperatures and incredible damage in a very short period of time. So that was not understood, in addition to the fact that the NFPA studies debunked the notion that you could tell whether it was arson or not based on these things like crazed glass or alligatoring. So we took this case in 2010. I think we formally accepted the case in early 2010, and we contacted the top fire experts in the country, people who had worked on the development of new standards in the 1990s, the NFPA, it's now called NFPA 921. It's basically a booklet that teaches fire examiners when they should declare a fire to be arson and when they shouldn't. And we talked to the top people in NFPA and said, here's these hundreds of photographs, here's the testimony that was given at trial, what do you think? And one of these guys is John Lentini, who is the leading fire examiner in the United States. He works out of Florida. And he wrote us an 80-something page affidavit in which he said, there is absolutely no indication of arson in this fire, and everything is entirely consistent with the story that Mr. Gavitt told all along. We got another top expert. He did his own review. He came to the same conclusion. Now, the most important thing, though, for Mr. Gavitt's exoneration was those little spikes on that gas chromatogram, because that's still the most devastating evidence. 2 of the 17 living room carpet samples have gasoline on them. But we found the original gas chromatograms. So we sent them out to John Lentini, who is also an expert in gas chromatography, and to a man named Craig Balliet at Purdue University, who has nothing to do with fire science, but is considered the #1 gas chromatograph guy in the country. And they both looked at these gas chromatograms and said, there is no gasoline on any of these 17 gas chromatograms. We have no idea what the food science guy saw but there's absolutely the signature for gasoline is missing from these 17 samples. So that pretty much sealed our case for us, we thought. So in September 2011, we took all of this new information to the prosecutor. His name is Ron Schaefer in Ionia County, Michigan. He had nothing to do with the original prosecution of Mr. Gavitt. It probably helped our case that the original prosecutor had been forced to resign in disgrace some years later after a sexual indiscretion. These things help. And we took it to Mr. Schaefer, and Mr. Schaefer said, let me consult my own experts. And this took quite a while. It took 9 months. Mr. Schaefer then talked to a series of his own experts around the country, both in gas chromatography and the new arson science. And his experts came to the exact same conclusion that our experts did. His experts wrote reports saying that there's zero evidence of arson in these photographs. The gas chromatographs do not show gasoline, and in fact, all of the evidence is more consistent with the theory that David Gavitt, or the story that David Gavitt said, than the theory that the prosecution promulgated at trial. Remember the story. It's not really, it doesn't take that much imagination to come up with how this fire started. They went for a brief interlude to have sex. They left the TV on. They left candles burning. They left cigarettes smoldering in the ashtray. And for those of you who were paying close attention, what else did they leave that probably precipitated this fire? The dog. They left the dog in the living room. Probably the dog knocked over the candles or knocked the ashtray over. But we'll never know. The one thing that you learn from NFPA 921 is caution, that you have to be very careful about declaring fires to be arson. As a result of NFPA 921, the number of fires declared arson in the United States has dropped precipitously. In 1988, just a few years after David Gavitt was convicted, 25% of the examined house fires in the United States were declared to be arson. Now the number is 6%. So if you think about that for a little bit, and you do a little math, I know I'm lawyers, law students, I know. But if you do a little math, you realize that that means that about 3/4 of the fires that were declared arson in the late 1980s wouldn't be declared arson today. Now, does that mean all 3/4 of the people who were declared arsonists back in the 80s are innocent? No, because we can't be sure. And what NFPA 921 teaches us is to be cautious about declaring fires arson. So some people who are committing arsons today are probably getting away with it because we're more cautious about declaring it arson. But we know that there are a lot more of these cases. And I'll mention a couple, and then I'll quit and take questions. One famous case that is virtually identical to David Gavitt's is the case of Cameron Todd Willingham. Does that name ring a bell? Anyone heard of Cameron Todd Willingham? No? Okay. Cameron Todd Willingham lived in East Texas with his wife and 2 children, 2 young children, just like David Gavitt. They had a fire. Unlike David Gavitt, both Mr. Willingham and his wife got out, but the 2 children died in the fire. Unlike Michigan, Texas is a death penalty state, and so based on almost identical testimony given against David Gavitt, minus the gas chromatogram, but the same pore patterns, crazed glass, alligatoring, the whole stuff, Cameron Todd Willingham was convicted of 2 counts of murdering his children and sentenced to death. In 2004, as his execution date was drawing near, a group of these top fire scientists, schooled in the new ways, took a look at Cameron Todd Willingham's case and concluded that there was no evidence of arson and that all the evidence was entirely consistent with an accidental fire, as Cameron Todd Willingham had said. This information was presented in the form of affidavits to Texas Governor Rick Perry, who declined it, and Cameron Todd Willingham was executed by lethal injection. This case has been written about extensively, and if you want to read a horrifying account of the Cameron Todd Willingham case that will maybe keep you up at night, if you Google David Grann, Grann, in Cameron Willingham, David Grann wrote a massive piece for the New Yorker about 2 years ago about the Cameron Todd Willingham case. Same evidence that was used to convict David Gavitt. Unfortunately, Cameron Todd Willingham was executed. We have, at the Michigan Innocence Clinic, now taken 3 more arson cases because we know that there are many more such cases. None of the cases are as old as the Gavitt case, but what we've discovered in these cases is that some of these people who were giving this testimony in the 1980s, this now discredited testimony, are still giving it today. So our other 3 arson cases are all more recent. One of them was a case in which a man was convicted of a house fire in 2007 based on testimony that was essentially identical to that given in David Gavitt's case 22 years earlier. There was no mention of NFPA 921, no mention of the new methods of fire science, and the defense counsel was apparently completely unaware of it at all. So, unfortunately, some of these guys, especially the old-timers, who were taught to diagnose fires the old way, some of them never got with the program. Some of them never got the training after those old ways were discredited. And so a few of these people are still out there. The 2 people who testified against our client in 2007 retired. Not soon enough, but they retired. I think it was Max Planck who once said that physics progresses 1 funeral at a time. And certainly that's true with fire science. There's still a few of these old-timers out there still giving the old bad testimony and still getting away with it. But gradually they're going away from the scene, and we're seeing, therefore, the decline in the number of fires that are declared arson to probably something approaching the true number, which is really a small percentage of house fires are declared arson. Okay, I'm going to end by just mentioning a little more about the day of exoneration. Yay, it came back. So after 9 months, Ron Schaefer, the prosecutor in Ionia County, called us up and he said, okay, I give. You're right. And so we went. We got an order signed by the judge ordering that Mr. Gavitt be released. We went to the prison to pick him up. I already showed you that photo of us. Those were all of his worldly possessions in that cart. Mostly he had a typewriter that he used to type letters asking for help was in that cart, and his clothes. And we picked him up and we said, David, where do you want to go? Now, we've done exonerations before, and the answer to that question varies. People want to go get a steak. People want to be driven to mom's house where there's a party waiting for them. It varies. David's answer was absolutely clear. I want to go to the cemetery. He had never been to the cemetery. Remember, he was in the hospital for 30 days, and then he was arrested from the hospital. So he had never been to the gravesite of his family. And so he insisted that we drive an hour from the prison straight to the cemetery where his wife and 2 daughters were buried. So we did. And there he is. He stayed there for 2 hours without saying a word, while we largely wept uncontrollably. I am happy to report that David was given a job. The Detroit Free Press did a very large story about the case. 60 Minutes is going to do a story about the case. The American News Magazine is going to do a story about the case. And the publicity helped. Unlike so many exonerees who have a very hard time getting back on their feet. And David is certainly struggling to get back on his feet. But because the publicity in his case was so good, Steelcase, the furniture factory in Grand Rapids, where he worked when all this happened, called him up and offered him a job. So he's now back making furniture again in the same factory he was back in 1985. And he has met a woman and married. So he is starting to put his life back together. Though, whenever he talks about the fire and the conviction, he cries. Every time we met him in prison, he cried. And he still believes to this day that he was weak because he didn't die in the fire as well, that he went out the window instead of trying to continue to fight his way to the nursery. So a somewhat happy ending to the saddest case that I've ever handled. But that's it. That's the exoneration of David Gavitt. Thanks.
So we have time for some questions.
All right. I'm going to grab some water.
Sure. Any takers? Anyone interested in posing a question?
Hi.
Hi.
I just have a.
Is this on?
That's not my question.
It's not amplified.
Okay.
It's just recording your question.
So I totally understand with Mr. Gavitt how when you're left entirely with forensic evidence that you can get that result. With Cameron Willingham, didn't his wife testify? I mean, I just curious to know what was the overall.
Well,
you know.
there was the other significant difference between Cameron Willingham and David Gavitt was Cameron Willingham was not a beloved character. Cameron Willingham was a wife beater, and that came out at trial that he had beaten his wife before. So she was, I think, on board with the idea that he was such a creep that he might have set the fire, and that certainly didn't help his case at all.
Thank you.
You mentioned frontline before with the Norfolk 4, but there is also a frontline on Willingham's
Yes,
case.
there is.
I think it's death by fire.
Right.
So if you Google that, it's great.
It's good.
Too.
Not as good as the Norfolk 4 one,
The
but it's
Norfolk
good.
4 is fantastic, and
Yeah.
all frontline criminal justice stuff is
Yeah.
a must watch. Other questions, comments? Yeah. Leanne?
Just a question. So in an innocence project where you are dealing exclusively with non-DNA evidence cases, obviously it seems arson and the new forensic science around arson has been pretty big for you. And I'm just wondering what are the other sort of cases you're dealing with besides arson? Like what else is there that's
Sure.
prominent?
I'll mention a couple. Our first case that we took in the clinic was an uncle and a nephew, Deshaun and Marvin Reed. The first case we won. Actually, it was the first case we took as well. And there, the forensics exonerated our client. So it wasn't that bad forensics convicted them. It was that the forensics exonerated our client. A man had been shot in the back of the neck, and he blamed the Reeds. He knew the Reeds. They had a long feud, and we thought that he couldn't have seen who shot him. He was driving a car, and he was shot in the back of the neck and paralyzed. And we thought he couldn't have seen who shot him. And at trial, there were two eyewitnesses on the street who saw the driver get shot, and they both contradicted his account. They both said that our clients weren't there, and they said not only were our clients not there, they said this guy stepped out of an alley and fired the shot as the driver went by. And one of the two eyewitnesses said, and I know the guy who was shot in the alley. I mean, who stepped out of the alley. His name was Tyrone Allen. And what we learned subsequent to that was that Tyrone Allen was a real person who was killed about 6 months after the shooting while he was committing a carjacking in Detroit. And on his dead body, the Detroit police found a .38. And ballistics testing showed that the bullet that was pulled from the victim's neck came from Tyrone Allen's .38. So there was forensic testing that actually bolstered the testimony of the eyewitness that it was Tyrone Allen who committed the shooting. And then, in addition, the victim recanted. The victim came in and admitted that he actually didn't see who shot him. And he just assumed it was our clients because there had been a history of animosity between them. But now knowing what he knew, by that point, he said, yeah, okay, it makes sense. Tyrone Allen hated me too.
A lot of people want to be dead.
Yeah. The other scientific thing that I don't know if it's not become as much of a specialty for us yet, is shaken baby syndrome. So one of our exonerees is a woman named Julie Balmer, who was convicted of shaking her nephew almost to death. And we were able to win that case because when we got the CT scans of the baby's brain, what they showed to every competent pediatric neuroradiologist who we showed it to was the baby had a stroke. The baby had something called venous sinus thrombosis, which is a rare but not that rare childhood stroke, and it had been simply misdiagnosed. And so her conviction was reversed, and they actually did retry her, but it was a walk for us. It was a very easy. When we had 6 of the top neuroradiologists in the country all testifying for free that this was a stroke. We've taken one other shaken baby case, and we're on the verge of taking another one. I am a co-author of an article that just came out, along with another Innocence Clinic professor at Wisconsin Law School, a pediatric neuroradiologist and a forensic pathologist, a major article in the Houston Journal of Health Law and Policy about shaken baby syndrome and the challenges to it. I don't know what percentage of those cases are wrongful, but certainly some of them are. Certainly some of them are. It's overdiagnosed. Yes, sir.
Let's get you the microphone.
So you mentioned prosecutorial misconduct at what point. Could you go into that and just tell us your advice for those of us going into prosecutorial work? What's the most important thing we can do to avoid this?
So I should have made this point when I talked about prosecutorial misconduct. I really believe that there are almost no evil prosecutors out there. I really believe that the prosecutor who wants to convict the innocent guy just doesn't really exist. I really want to believe that, and I do believe it. It's tunnel vision is the problem. Is the case gets to a prosecutor, the police have said, this is the guy, and it's the natural human thing that we have to guard against, too, in the clinic, of you've got your theory, our theory being innocence, the prosecutor's theory being guilt, and it's the natural thing to disregard evidence that doesn't fit the theory. It's like, oh, that's flawed. That's flawed. So in the Claude McCollum case I mentioned earlier, where there was a video showing Claude McCollum asleep in a chair during the entire period in which the murder of Carolyn Cronenberg could have occurred, the prosecutor had that evidence. He didn't turn it over. Why didn't he turn it over? Because he was convinced that the timestamp on the video had to be wrong. How did he know it was wrong? Because Claude McCollum had confessed. So he was convinced that this was irrelevant, piece of trash. So I don't think it ever occurred to him. I don't think this was a bad guy. I think it was a guy who just couldn't see the importance of this evidence because he had the blinders on. He had his confession. This was the guy, a very, very bad guy, did a very terrible thing. And he couldn't see it. And so trying to approach cases with an open mind is hard because it's basically asking you to not be a human. I mean, to think more like a Vulcan, I'm a Star Trek fan, or a robot. And it's very hard. But that's it, to occasionally step back and say, is there anything I'm missing here that should make me have questions? Yes?
How are the poor spots explained?
Oh, can we just get you to do it on mic? Sorry, just so we record it.
Plus, we get a workout for the associate dean.
That's right. Need exercise.
Yeah.
I'm curious as to how the poor spots are explained in the Gavitt case. Was it just a natural occurrence like the alligatoring and the crazed glass?
Yeah, it just happens. So one of the things that happens during a flashover, and the experts in our case all agreed that this was almost certainly a flashover fire. So a flashover, you get a closed compartment, you have the gases build up near the ceiling, and boom, okay, and it gets really hot. And one of the things that happens when it gets that hot is stuff turns to liquid. Stuff liquefies, like the carpet. And so the carpet turns to goo, hot, flaming goo that burns the floor. but it doesn't do so evenly. And in fact, what the deal with the pour patterns is, more often than not, is it's actually a reflection of where the furniture was. So the furniture can shield some parts of the floor or the carpet from the incredible heat coming from the ceiling, like basically a shadow. And other parts get the full exposure. And so that's typically now the thinking is, usually that's what the pour pattern is it's differential amounts of heat that the floor was exposed to.
Thank you.
This guy.
Thanks. I just wanted to ask a quick question. And again, I have no scientific background nor have I any understanding of it. It's just one of the things that bothered me when you were discussing some of the evidence in the Gavitt case. The gas chronometer, and I gather that they had carpet samples that survived the fire from the living room, which seems somewhat odd in the sense that it seemed like a massive fire with a massive amount of heat.
Right.
If there was a finding that there's gasoline on a fire in a room with that level of heat emanating from it, wouldn't the gasoline have burned off? Or was there an expectation that that would have happened?
You get good question. I think the answer is that the gasoline burns off, but it doesn't burn off completely. So when you any kind of fluid you light, you get remnants. You get solid remnants. Certain chemicals are left, basically, in the ash. And so what the gas chromatograph was looking for was the signature of burned gasoline. And gasoline has a lot of components. It's not just one thing. So it's not, if you have just a single substance like, I don't know, mercury, that's an element. So you're just going to get one spike. But with gasoline is made up of a mixture of things. So you're going to get a mix of spikes. And interestingly, I did learn in the course of working on this case that the signature for gasoline has changed as what's sold in America changed. It used to be leaded gasoline in America, and then the blends have changed. So they have to calibrate it to what were the types of gasoline that were sold in America in 1985, and those signatures were missing.
Thank you.
I just wanted to know, do you get a lot of support or help from the state? Because I noticed in your FOI request, for example, they turned over everything they had, including the gas chromatograph thing.
Yeah.
Yeah. So is that a consistent response? Like, do they normally give everything that they can to help, or?
I wish.
Okay, that's what I
No. Michigan has a great FOIA law that requires the government to respond within 10 days of when we file a FOIA request. I know, 10 days, isn't that great? And tell us what they have, and then they can charge us a reasonable fee for the copying of it, but not an exorbitant fee. The Michigan State Police, for whatever reason, are really good at responding promptly and fully to FOIA requests. We've had a lot worse luck with other police agencies, particularly the Detroit police. More than half of our cases come from Detroit. And we've actually sued the Detroit police twice so far, and a third lawsuit probably imminent, because trying to get them to actually even acknowledge our FOIA requests. And it's not like we sue them on day 11. I mean, we sue them on day like 300. We keep, we're constantly on the phone trying to get them to respond. They are under-resourced, so we try to be understanding, but it's very hard slog with them.
It's coming.
Notice how never two people at the same table.
I know. I wish they would cluster, but.
Yeah.
I'm just wondering, you mentioned that some of the old-timers are still testifying to these discredited theories on fire investigations. How are the courts allowing this, and don't the prosecutors have some sort of duty to put forth the best possible expert? Like, why are these people still around?
Great question. First of all, they're around because the defense doesn't challenge them. In Michigan, at least, the under-resourced, under-trained, typical defense lawyer is only vaguely aware, if at all, of what we call in the United States Daubert, the requirement that scientific evidence be vetted by the judge that there should be a proper challenge to scientific evidence, and the judge then should make a call as to whether this is valid scientific evidence. I have never seen a Daubert hearing in the hundreds of transcripts I've read. I've never seen one. So I've never seen a case where the defense lawyer got up and said, this evidence should be excluded on Daubert for Daubert reasons. As for the prosecution, I think the prosecution, and it's the problem we've seen across the forensic sciences in the earlier part of my talk, is the prosecution tends to call the same people again and again and again. They call the local guy who gave great testimony in the last case saying it was arson, and so they're going to call that guy again. The prosecutors aren't scientists either, so they don't really know what's wrong with this. So it's a hard slog. I'll tell you about arson case number 3 we just took. It's a fire in Battle Creek, Michigan, and the prosecution's theory again is that our client, upset because he was shorted when he bought crack at that house earlier, came back and dumped gasoline on the front porch and started a fire. So they tested the front porch area using gas chromatogram for gasoline, didn't find any. So that's a problem, you would think, for the prosecution's case. So they brought in a guy who is a combination fire examiner and dog handler. And he brought his dog Samantha, and he said Samantha alerted that there was gasoline on the porch.
Well, there you go.
Yeah. And he then proceeded to explain that Samantha's nose was 1,000 times more sensitive than a gas chromatograph.
How well was Samantha cross-examined?
Yeah. So Samantha's a great witness against our client. And that's it. I mean, there is no other scientific evidence that gasoline was involved in this fire other than the dog handler / fire guy's testimony that Samantha alerted, and Samantha's nose is 1,000 times better than a gas chromatograph. But we've researched that claim. No. A dog cannot detect gasoline 1 time more sensitive than a gas chromatograph, much less 1,000 times. Just handle it.
It's not really a question.
Okay. Comment?
Okay, comments are welcome to you.
Thanks. My father is actually a platoon chief with Toronto Fire and a member of the arson task force, and he's met with Mr. Lentini. I spoke a bit with him about this case, and he actually told me that many people still believe that Mr. Gavitt was guilty. It just goes to show you, I guess, that many people are stubborn or slow, I suppose, to accept evidence that goes against their preconceived notions.
Mr. Lentini said that?
No.
No. I mean, Mr. Lentini said that people believe Gavitt is.
My father said that. He explained that people in Toronto, at least, that I suppose aren't as connected with the case, believe that Mr. Gavitt is still guilty.
Huh. Well, that's interesting.
There are people here who believe that Guy Paul Moran was guilty too, and there's some other unindicted, this is said from time to time, co-ejaculator.
Yep, the unindicted co-ejaculator.
This is the insistence in the face of evidence of innocence that, reconcile the evidence of innocence by changing the theory. The Norfolk 5 case is a great example. The 4 is a great example of that, where the prosecution keeps adjusting its theory.
We were worried about that, when Gavitt was exonerated, that would the local people believe it? And it's all anecdotal, but all of the people that we talked to locally were behind it, and especially when the local prosecutor, did what he did. That really helped. I think if the local prosecutor had fought it, people would have had a lot harder time believing it. We, in fact, the day of the exoneration, we went to the courthouse to get the judge's order to take to the prison to get Mr. Gavitt out, and it was just the woman in the clerk's office who we had to get stamped the order, put the official seal on it. She said, "I always knew he was innocent." She just told us that out of the blue. Now, whether she really thought that or not, I don't know. Or late jumping on the bandwagon. But
any last questions? Can I just ask you a quick question, David? What do you make of these cases and what they say about the burden of proof and the presumption of innocence? Does it, Blackstone said better to let 10 guilty people go free than convict 1 innocent. Do you think that's true in practice, based on our experience with these cases? Is something wrong with how the burden is applied in practice? Is there really a presumption of innocence, or is there something else happening in these cases? I've always puzzled about this.
Yeah,
I'll throw it at you.
Boy, I don't know. But I think in a bad forensic science case, the burden goes out the window. I think if you have an expert who says it was as the prosecution says it was, can the jury meaningfully apply beyond a reasonable doubt to that? In most cases, I don't think so. I think it's very hard for a jury to say, even when a scientist would say, well, there's a substantial error margin here, and there's a substantial chance that my opinion could be wrong. When the jury hears the magic words coming from the expert, in my opinion, it was X.
The case is over.
The case is over. Yeah. So I think the forensic sciences cases are especially dangerous for effectively reducing the burden of proof. And I think the fact that so many of the DNA exonerations have been forensic science cases confirms that.
Well, great. Thank you very much. We have a small gift for you here, David. So, and we very much appreciate you making the trek up to Toronto and joining us this afternoon.
Now, the guy at the border today said, "You're not getting paid for this, are you?" So
This is it's a gift.
okay, because I guess I'm not allowed to work. Thank you.